Good morning, everyone. I believe that we have the Governor's Page program with us this morning. Seeing heads nodding, I appreciate that. Thank you for being here with us. It's interesting as you have this opportunity to explore other branches of government. So we welcome you to your courtroom. Our next case is Cowperthwait versus Salem Baptist Church, and we will hear from the appellant.
May it please the court. Good morning. My name is Camilla DeBoard, and I represent, along with Alicia Bray, both from Bovis, Kyle, Birch, and Medlin, the defendant appellant, Salem Baptist Church, Incorporated. I'd like to reserve 5 minutes for rebuttal. There's one main issue in this case, which is whether dismissal under Rule 41 for failure to prosecute by the trial court was proper. This court should uphold the trial court's dismissal of the matter for failure to prosecute pursuant to Rule 41 because the trial court did not abuse its discretion in sanctioning the plaintiff appellees. The Cowperthwaits for their lack of prosecution of their case. I will outline first the abuse of discretion standard as it's important here as it relates to Rule 41 and the inherent authority of the trial court to sanction individuals and attorneys, and then walk through the factors utilized by the Court of Appeals that were outlined in a Court of Appeals case, Wilder versus Wilder. This court should utilize these factors looking at the totality of the circumstances, including the staleness of the statute of limitations of the claims to confirm dismissal was appropriate. The Court of Appeals in their decision was much more narrow than most of the case law in North Carolina with regard to analyzing the prejudice in this case and looking at whether lesser sanctions were reviewed and appropriate in this case. Before I get through to the factors of Wilder, the abuse of discretion standard is important here because it must be manifestly unsupported by reason with regard to the trial court's order for it to be overturned. Minor versus Minor outlined the power to dismiss and sanctions don't originate with the rules of civil procedure or Rule 41 for the trial court. It is long-standing and inherent in our courts that trial courts are the gatekeepers. They establish rule and order and must be respected. When rule of law and delayed conduct that is unreasonable is completed, it is the work of the trial court to make sure everything is streamlined and make sure the rules are followed. The abuse of discretion standard therefore applies to sanctions, including sanctions under Rule 41, because it is the inherent discretion of the trial court to make sure order is followed. They are given great deference as a result, and so they are only upset only by a show so arbitrary that is not reasoned. While dismissals are extreme, they need to maintain control of their docket in the trial court. The exercise of this inherent authority demands appellate deference to the trial court's judgment on how to control their docket. There is no warning that would be required for a dismissal in North Carolina as a result. That is outlined in Reed, Blumenstein and Company. While there was an argument in Blumenstein that there should have been a warning before a dismissal, the court found that the dismissal would give, if there was a warning, it would give one opportunity to disregard the court's schedule without fear of penalty, regardless of harm. That cannot stand with the way that the trial court is ordered and the way that our rules should be followed. There is
you filed a motion to dismiss under Rule 41B.
Correct.
So certainly here, all the parties knew going into the hearing that that was one of the possibilities, because that was the relief that's requested in the motion.
Absolutely. And it was requested in the alternative, a motion to compel. There were two options. The Rule 41 motion to dismiss, which that rule was specifically outlined in the motion, was fully argued. There was case law on both sides to support it at the trial court level, as outlined in the transcript. And that was the majority of the argument that was propounded by Mr. Alligood at the trial court level. There was notice of this not only by the motion that was filed at least a month before the hearing, but there also was time and time again requests for attention to their case. In this case, just as a brief background, the matter that gave rise to the complaint happened June 14th of 2011. We are here in this case starting in 2020 because Ian Cowperthwait was a minor at the time that this accident happened. The accident happened on the property of Salem Baptist Church, which was a camp for young men and individuals. The statute of limitations is important here because it creates this long time period and age. Ian Cowperthwait had until he turned 21, so 3 years from his 18th birthday, by the statute of limitations to file this case. He filed it within a month of the statute of limitations running. There was no filing previously for the medical bills that were incurred by Mr. and Ms. Cowperthwait, Ian's parents. That was filed at the same time in July of 2020. The concern with that is statute of limitations are the outside limit of when the legislature has decided cases are stale. So they have weighed, if you look at Carlisle versus Keith, if you look at case law regarding statute of limitations and the basis, the legislature has to weigh what the unfairness is and where that line would be. So, and I understand the court, the justices have heard a lot of argument about statute of limitations yesterday as well, and the legislature is weighing where the unfairness lies and creating that statute as the line. So here in this case, we are at the line of the statute of limitations. And then there is an 8-month delay of anything by the plaintiffs in the case. The case is filed in July. There is in the record, no notice or anything done until December when there is an entry by Mr. Alligood and then an answer filed in January. The important thing to note is that the answer was filed by defendants to move the case forward because the plaintiffs themselves were not. It was the defendants who have no obligation to move the case forward, who had to file the answer specifically to send discovery so that there would be some sort of legal obligation to provide documents and information about the claim. Even with that filing, which was done solely to get this information because of the delay, there still was continued delay. There was an extension that was given. Then it was past the extension. And we are 13 months at the motion to dismiss hearing where there's only limited discovery that was served after the motion was filed on the eve of the hearing.
I do want to make sure I understand your argument regarding the tolling period. And I understand that there might be a different situation with regard to the parents as the plaintiffs as opposed to Ian, who was the minor for whom the statute was tolled. But you're not suggesting that the fact that he was entitled to take advantage of that tolling period should also be considered as part of the delay, are you? Because then it would seem to me that anytime a minor takes advantage of a tolling provision, they can file but then be dismissed because they haven't prosecuted the case.
It is a factor. However, it is compounded. It is a compounding.
Well, so I do hope you'll get to the Wilder factors because it seems to me it's important for our court has never explicitly adopted those, right?
Correct.
But it seems to me a part of the question here is, what was the evidence that the trial court had of prejudice? And in particular, the Court of Appeals seemed concerned that there were just conclusory statements about witnesses' memories get poorer and the witnesses might not be available without any actual specific details of any particular witness who either was attempted to be contacted and was no longer available, or just nothing beyond these conclusory statements that you could make about any time there's a delay.
The Court of Appeals expressed concern with that issue. The case law, Lazier versus Stanley, Martin, and Don't Do It Empire versus Tentex, both are cases that address the prejudice. Lazier gave more examples other than just the memory of witnesses fading. They also included the ability to seek and obtain medical records, or treating physicians, or any other data. And the cost of litigation can also be a factor.
But I think what the Court of Appeals was getting at is those all may be factors, but in order to apply the Wilder test, you actually need to have evidence of that happening in this particular case.
Correct, and there is evidence of this happening in this case.
So what is that?
The answer and the discovery was specifically filed for the sole reason to get this information due to the delay and inability of the plaintiffs to provide the information, and that was a cost. In addition, the medical records, when they actually were received on the eve of the hearing, they were incomplete. Unfortunately, this is a situation where it is so delayed we do not know what we do not know. And that is the concern and the prejudice, Your Honor.
But wouldn't that be true in every case? There's nothing, it seems to me that's not unique or specific to this case. And if it's true that it's present in every case, then there would always be grounds for dismissal.
I respectfully disagree. In most cases, Justice Earls, there is some knowledge and understanding of the injury and some knowledge and understanding of the treating providers at some point, even prior to filing suit by both sides. In this case, there was not. In 2011 and 2014, the insurer for Salem Baptist Church requested of the parents, Mr. and Ms. Cowperthwait, for any information regarding the injury, and that was failed to be given. Even when Ian Cowperthwait turned 18 himself, there was no communication by Ian himself, and even though they hired an attorney in 2019 after he reached the age of majority, there was still no correspondence until the eve of the statute being running in June of 2020, when the attorneys in the trial court level contacted the insurer for Salem Baptist Church to say that they would be filing to protect the statute and would attempt to get the records as soon as possible. And those empty promises continued every email and every correspondence that counsel for the Cowperthwaits had up until the motion to dismiss or when discovery was received.
And so let me ask you one more question then about the Wilder factors. As I understand the Court of Appeals here, the delay, the court is looking for essentially delay and failure to prosecute on the part of the plaintiff themselves, not necessarily their counsel. And so I'm wondering if in the record in this case, there's any distinction that the court was able to look at what the plaintiff himself was doing that caused the delay as opposed to potentially his counsel not doing what they were supposed to be doing.
So courts can look at both the counsel's actions and the individual's party's actions. Case law is clear that we are not married as parties to one attorney, and attorneys are agents of the parties. So while attorney conduct may be separate, they are still not excused completely from, for example, I think it's Chris versus Hill, when an individual did not show up, an attorney did not show up for a hearing and the case was dismissed, the party still had an obligation to appear and prosecute their case as well. So both the conduct of the attorney and the plaintiff themselves can be considered in this. With regard to this case, Justice Earls, the conduct of the parties can be seen not only predating the lawsuit being filed, but also postdating. If you look at the date that the HIPAA authorization was signed, it was signed March 19th of 2021. We have no record of any other authorizations to obtain medical records before that time period. So for the time period of the statute of limitations for the medical bills, which would be 3 years from 2011, we have no record of those being obtained. And then for the tolling statute for the minor, Ian Cowperthwait, for those 10 years, we have no record of those records attempting to be obtained. The only record we have of that is from March 19th of 2021, which was after the responses were legally past due. And at that point, that establishes that the Cowperthwaits had done, at least by the record, nothing to prosecute their case by obtaining the necessary information to support their case. The reason medical records are important in this case is because it's a personal injury action. A personal injury action requires some sort of support by the plaintiff to confirm that there is an actual injury to get more than nominal damages. Those include medical records, and in complex medical cases, such as here where there's a dental injury, it would include testimony from an expert. Another piece of information that was never disclosed, even in the discovery responses that we received, were whether there would be experts. There was an objection saying it was not timely 13 months from the filing of the lawsuit after one administrative session had already passed from the court. And so, that delay compounded with the idea that when we did receive the records, the dentist that saw him the first day, who was his regular dentist, those records were never provided. It's my understanding that dental records have a 10-year retention rate in North Carolina, but I can certainly provide that information if that, in a memorandum if that's needed. So the concern is, even at the point where we were at the motion to dismiss level, those dental records or the prior history of dental records before the incident may no longer have been available, just by the retention of certain medical providers. So the prejudice is there not just from counsel, but also from the individuals as well. If you look at Don't Do It Empire verse 10 text, which was a 2016 Court of Appeals case, that was a dismissal for failure to prosecute. While the procedure of the case was different and the delay was a 19-day delay for failure to amend their complaint and include necessary parties, the court dismissed the case for failure to prosecute for a variety of reasons. In that order, which was upheld by the Court of Appeals, the only statement regarding prejudice was number 3 of the court order in Don't Do It Empire, which was that plaintiff's actions have created a high degree of prejudice to the defendants. And then they outlined the sanctions short of dismissal in that paragraph, that the willingness to deliberate delay this action was a factor, and that it made clear that there was no intention of cooperating, and failed or refused to comply with the motion or the court's order to amend was only a factor. But it was not the deciding point, because the dismissal was based on failure to prosecute, not failure to follow a court's order. Don't Do It Empire and that finding and conclusion of law is consistent with the finding and conclusion of law in this case, which was conclusion of law number 3 in the order regarding dismissal for failure to prosecute. In this case, the trial court stated that the unusually old nature compounded with the 13-month delay to create prejudice, not only by the aging of witnesses' statements, but the ability to find experts and also obtain those records that were never produced. There's a case of Meeben versus Elliott, which gives an extreme example of prejudice as well. This is a 2021 case. In that case, there was a 4-year delay, and additional witnesses moved. One attorney died. This is the extreme example of prejudice. Meeben is not necessarily the only example of prejudice, as Don't Do It Empire versus Tentix has outlined. There are other examples that can prejudice your case absent witnesses dying or leaving the state. In situations where the defendants would not be able to provide a defense based on prior medical records in this personal injury action, that also creates a prejudice that cannot be overcome. We cannot recreate those records. And coming back to the idea and the question of Justice Earls is, how is every case we don't know what we don't know? Discovery is the legal way for us to obtain that. And even when we received those responses, they were so scant that we could not even confirm who the prior providers were or what we were missing. And so that again goes to the prejudice in this case that the defense would have in trying to move forward and defend their claim on proximate cause and personal injury. Going back to the Wilder factors, while this court has not confirmed that those are the factors to be used in North Carolina, both my friends to my left and our briefs use those Wilder's factors in establishing and looking at what was appropriate in this case. The
Wilder factors, if anything, are stricter really than what would be the precedent without Wilder, because this court has addressed the standard under Rule 41B, right, and just said the trial court has broad discretion to craft the appropriate remedy, which seems to me to be much broader than creating a test that articulates specific things that in the court's discretion it needs to contemplate before the ruling, right?
Correct. And that's important because Wilder is just factors. It is not a true bright line test. And so when you are even looking at Wilder itself, they use the totality of the circumstances, which is the judgment of the trial court, and give that deference in determining what is failure to prosecute. So when we are using a factor test like Wilder, it is not the same as it would be for a 1, 2, 3 test. There may be one factor that is less than the other in terms of proof. However, sorry.
Well, please finish your sentence, I'm sorry.
However, if there is one factor that is predominant, such as significant delay to not only create an issue for the court's time, but also for the defense of the case, then that could override and supersede another factor.
And my question is just, I'm looking for totality of the circumstances language in Wilder, but the court there concludes by saying, we believe that the factors recognized in Hillig as well as in our previous cases together give rise to 3 factors that the trial judge must address before dismissing for failure to prosecute under Rule 41B. So it does seem that in Wilder, the court was saying, these are 3 factors the trial court must address, and that's been, in subsequent cases, that's been filed. So I understand your position to be that this court should adopt the Wilder factors as the standard under Rule 41B.
Correct. Okay. But it is a factor test, and while they need to be considered, the factors in Wilder were created by looking at Link versus Wabash, which is a Supreme Court case from 1962. And in Link versus Wabash, they look at the history of litigation and instruct that you look at all the circumstances surrounding counsel's case, not even just the litigation. So the Wilder factors were made knowing that they are Link versus Wabash, totality of the circumstances. And they use the term factors versus test, which is important. Also, because we're dealing with sanctions, that marries to the fact that it is an abuse of discretion and deference to the trial court is given, that in Wilder and in the cases, you must look at the totality of the circumstances, and those are an outline of things that should be considered. So exactly what you said, Justice Earls, that those must be considered, and here they were. Each factor was outlined in the order by the trial court. The trial court in the order specifically cited to Wilder. Wilder was cited by both the individuals in argument and the transcript. This was the central piece of the trial court in determining whether these sanctions were appropriate and necessary. And the trial court found that it was. That leads to the third factor, which I have not touched on. The reason these sanctions short of dismissal would not suffice is because if we continue to move this down the road, it gives that one excuse. It gives additional time on the delay, which could have already hindered and destroyed the records. It also does not solve the fact that this has been pending in the court for 8 months and then at the hearing 13 months. In addition, the court adequately considered those factors because, as Justice Dietz noted, this was a motion to dismiss, but also a motion to compel. The alternate and lesser sanctions were present in writing and argued in front of the trial court. The trial court considered those. The court noted that in her order it was considered, and it's in line with the orders outlined in Badilla v. Cunningham and also in Re Pedestrian Walkway, where in the orders themselves it said in Re Pedestrian Walkway the court has carefully considered each of the acts and their cumulative effects and the available sanctions for misconduct and still chose dismissal. That's almost identical.
Counsel, if you want to save any rebuttal time, it's your discretion.
Yes, Your Honor. I would ask that you reverse the Court of Appeals decision and uphold the trial court's decision. Thank you.
Thank you, counsel. We'll hear from the appellee.
Good morning, Mr. Chief Justice, Associate Justices. May it please the court. My name is Nathan Wilson, and I'm here on behalf of the plaintiffs, Ian, Catherine, and William Cowperthwait. Dismissal with prejudice is a drastic sanction to be reserved only for the most extreme circumstances. Relying on precedent that this court unanimously affirmed, the Court of Appeals below found that the trial court's order failed to support that such circumstances had occurred, and so remanded the case back to the trial court. That decision should be affirmed. After listening to this court's discussion with my friend on the other side, I think there are 3 points where we disagree, and I'd like to provide some clarity. The first is the framework under which this court should examine the case. The second is the trial court's errors of law and its prejudice analysis. And the third is why the trial court failed to consider lesser alternative sanctions. To the first point on the framework, my friend on the other side has embraced the Wilder standard, and I know, Justice Dietz, you were asking, does Wilder bind this court? No, this court could adopt any standard that it finds appropriate. Wilder has only been used in the Court of Appeals. However, the last time a Wilder case came before this court, that was Lauser versus Stanley Martin Communities, LLC, this court did per curiam affirm it. So Wilder is helpful guidance, and also if you look at the last time this court examined a Rule 41 case, which I believe is Smith versus Quinn, it looked to delay, sure, but it also looked to the prejudice to the party, and it also looked to lesser alternative sanctions. So I think Wilder is in line with what this court looks to in evaluating whether a Rule 41B order will be upheld. Again, the most drastic sanction that can be opposed on a plaintiff in civil litigation. And looking to those, and looking to what the Court of Appeals did below, the Court of Appeals found that the trial court's consideration of prejudice and of lesser alternative sanctions was faulty. It did not reverse the trial court on delay, and so I'm not here to argue delay, to your honors. I'm focused on what came up before this court on appeal, which is prejudice and lesser alternative sanctions.
So it's interesting that you use the word faulty there, because this is something I'm struggling with. When we do know from this court's precedent that the standard of review is abuse of discretion, and that standard is very well settled in our case law. It's only an abuse of discretion trial court ruling if it's so manifestly arbitrary that it cannot have been the result of a reasoned decision. And one thing you could say is that sometimes what one judge might say is sort of faulty reasoning is still reasoning by the other judge. And I'm wondering here if one of the challenges you have is that although we may not think it was the better reasoned decision, the majority of the Court of Appeals certainly didn't think so, but that the trial court was engaged in a reasoned analysis of the Wilder factors, and just in reasoning that way, we don't think it was particularly strong reasoning, but that's not an abuse of discretion. So what's your response to sort of the fundamental standard of review issue?
Yes, Your Honor. Even in those cases where this court is looking at a trial court order for abuse of discretion, it will remand if there's insufficient findings of fact to explain how that abuse of discretion was utilized. And I think that's the key problem here, particularly if this court still finds its affirmance of Lauser persuasive, because what we have here is very conclusory reasoning by the trial court. The trial court says that a lot of time must have passed. Therefore, witnesses' memories must have degraded, people must have moved away. And that's the only testimony in the record as well, is trial counsel saying, well, there's children, they've surely moved away, there's surely been turnover at the church. But those are not specific factual findings. A specific factual finding is what we saw in the Court of Appeals case of Mebane versus Elliott, where the trial court order said the defendant, who was the subject of that malpractice action, had passed away during the 4 years that the case had been pending. And the paralegal had moved to Tennessee, and the file system that the law firm used had been replaced and files had been lost. Those are specific factual findings. We don't have those findings here, and so that alone could require remand, if nothing else, for the trial court to provide those factual findings. But I know this court has recently discussed the difference between remand versus reversal. As I view the record, there aren't facts in there that would support findings, and so a full remand is required as opposed to just a remand to find those facts. The evidence is missing. I know my friend on the other side discussed the prejudice of costs and hiring attorney. Again, those findings of fact are not in the order. There's no findings in the order about the cost of the attorney. And I also know this court doesn't find new facts on appeal.
But don't we, so one thing that troubles me about this case, if we were to embrace your reasoning, is how many other areas of the law are subject to trial court discretion and an abuse of discretion standard on appeal, and where the appellate courts routinely just look to very simple statements of reasoning from the court and then look to that and say, could there be evidence the court was considering to reach that conclusion? So, Rule 403 is a great example of the balancing test of substantially more prejudicial than probative. We would be putting a huge burden on trial courts if they have to start spelling out exactly what facts they're finding in those sorts of analyses, instead of the appellate courts being able to say, okay, it's the decision of reasons one, what evidence might they've been looking at? So I'm a little concerned about your assertion that the court here needed to stop and make a bunch of sort of fact findings, instead of us being able to look at the record and say, are there any facts that could have made this a reasoned decision? So are you saying there was insufficient fact finding in the court's ruling here, or are you just saying you think that this was not a reasoned decision on the facts in the record?
I think both, Your Honor. I think first, there is insufficient fact finding to the extent this court finds facts are necessary, and I do think Rule 403, which is an evidentiary matter that the trial court is shooting from the hip, shall we say, is going to require perhaps less factual finding than the death knell for an entire case, which is a Rule 41 dismissal with prejudice. And to the extent this court I know federal law does not control here, but to the extent this court finds it persuasive, the federal courts certainly consider the abuse of discretion standard. They apply it a little bit tighter in Rule 41 cases, for sure. But then, yes, there is evidence lacking because the defendant brought the claim, and this goes to my second point about the errors of law in the prejudice analysis. The defendant moved for dismissal under Rule 41, and it's bedrock law that the defendant bears the burden of proof. The defendant here did not provide the evidence that we saw in Mebane versus Elliott of the specific which witnesses had moved away, which witnesses had passed away. There's another case that my friend on the other side cited in their opening brief, which is the Anderson Green case. And in that case, the defendant actually brought evidence of a doctor. It's another kind of medical case. The doctor said, I looked at this patient 10 years ago. That was the time that the patient delayed after filing. I've forgotten even looking at this patient. So this case lacks the evidence to even draw those findings of fact, and to the extent this court still finds prejudice relevant, as it did in Smith v. Quinn, that would prevent affirmance on that ground. I think it is an unreasoned decision to dismiss an entire case with prejudice on delay alone.
What if the reasoning was this, which, as I understand, I think this was the trial court's reasoning, that in every case you're expected to comply with procedural rules, to promptly respond to other parties' requests and so on, and that there's always some harm in that sort of failure to prosecute or failure to move the case along, comply with deadlines and all those sorts of things. But in a case where there's a juvenile and you have this tremendously long extension of what would ordinarily be the statute of limitations, there's already a great deal of time that's passed. And every moment counts because it's just an ordinary experience of human life. The more time that passes, the more people's memories fade, the more documents slip away and are lost or destroyed. And so the court was saying, because this is one of those cases where already this time has passed, it's not because of that, but it's because now we're in this scenario where every moment counts, that this delay was prejudicial here in a way it wouldn't be in a normal case where 8 months doesn't matter that much. So why isn't that a reasoned way of looking at the prejudice here?
I have a couple concerns there. I think, again, that flips the burden of proof by putting the burden of proof on plaintiff to prove why there's not prejudice. And my next concern would be that that would open trial courts up to override the legislature's policy decision to set certain statutes of limitations. If a plaintiff who's entitled to wait to a certain period of time then files his case at the end of that, and the trial court disagrees with that period, with the General Assembly allowing him to do so, then they can be on the edge. So the instant there's a mistake, they dismiss the whole case. Again, I don't want to bring up delay unnecessarily, as that's not before this court on review, but I think it is telling that the trial court excused everything that happened after April, and the discovery violation wasn't until March. So as far as a technical delay, we're only looking at 1 month here. And so when we think about the prejudice, to the extent witnesses' memories were degrading and witnesses were moving away, there's no way in the record to determine whether that happened while the statute of limitations period was running versus afterwards. And finally, I'd like to move to the second part of the case, the second prong, which is up before the court, which is Rule 37. When we look at why the trial court dismissed the case, what prompted this dismissal? It was plaintiff's delay in discovery. And that can be seen on page 75 of the record, paragraph 17, where the trial court names the school records and the social media records that were not turned over. Those were never requested until plaintiffs served discovery. So this is a discovery issue. And that should give this court pause, because Rule 41, as my friend on the other side recognized, comes from a trial court's inherent authority. And it exists for extreme circumstances. But the General Assembly has already set forth a rule of what should happen when a party is late in discovery, and that is Rule 37. So I think another abuse of discretion here is the trial court jumping immediately to the more extreme Rule 41 and ignoring what the General Assembly says should happen when a party is late with discovery under Rule 37.
If your argument is this is a discovery sanction and a Rule 41 dismissal is just not an available option for that, is that something that your client needed to tell the trial court? Because I read the transcript and I didn't see that argument made to the trial court, that this is not an available option because all you're finding is the discovery sanction. You're not saying failure to prosecute or these other things that are described in Rule 41.
Your Honor, I think my client did discuss the discovery issue. I don't think he mentioned Rule 37 specifically. I would leave it to this court's discretion on how broad or narrow to draw preservation, particularly as an appellee here, where we're bringing up alternative bases for affirmance. I do know, and again, federal law is not binding on this court, particularly in Rule 41, but there was, I thought, a helpful case out of the Seventh Circuit where the Seventh Circuit encountered basically this exact issue. There's a plaintiff, he brought an injury action, the defendant informally sent him a medical release and asked him to sign it. The plaintiff never responded. He sent it again, plaintiff did not respond. He sent it a third time, plaintiff finally responded, that was just to ask some questions and push back. Defendant sent it a fourth time, modified a little bit, and noted, hey, if you don't respond to this, I'm going to move to dismiss your case for failure to prosecute. He sent it a fifth time, plaintiff doesn't respond. He moves for failure to prosecute, and the trial court dismissed it. And what the Seventh Circuit said is these may have been informal requests, but really, this was a discovery dispute, and it should have been handled under Rule 37, and it's abuse of discretion for the very first time there's any dispute, any delay, for the trial court to completely dismiss the case. And I was looking over the cases that this court has had before it on Rule 37 dismissal, which my friend on the other side cited. That's Badillo and that's Red Valve. And again, this court did not issue opinions in those. It per curiam affirmed the decision of the courts below. But when we look at Badillo, the plaintiff in that case had already been brought up before the trial court on a failure to prosecute claim. It convinced the trial court, please don't dismiss my case, I'm going to shape up, and then missed discovery completely. Did not take an extension, did not turn any discovery over. The Court of Appeals found, well, of course it makes sense that lesser sanctions aren't going to work here because you've already been warned, you've already had the threat of sanctions and you did nothing. And the same thing happened in Red Valve. In Red Valve, I believe the trial court counted 67 separate instances where the plaintiff had previously disregarded, or not the plaintiff, but the party had disregarded his orders, and he still lied to the trial court. He still failed to produce discovery. We don't have that here. This is the very first instance where a plaintiff shows up to the trial court for a hearing and his case is dismissed completely. And I think that provides another ground for abuse of discretion. This court has no further questions?
I do have one more question. I noticed you didn't bring up the point about the distinction between the parents and Ian in terms of who could be responsible and therefore have the Rule 41 judgment entered against them. But I just wanted to check with you. Again, I looked in the record at the argument in the transcript of the trial court hearing and also in your Court of Appeals brief. I didn't see you challenge the Rule 41 ruling on the basis that some of the parties in this case weren't even properly subject to the motion. So is that to the extent that's in the case right now, was that preserved in your view in the lower courts?
Justice Dietz, I also do not remember it being brought up either.
Thank you.
All right, well, for these reasons and the reasons stated in our brief, we would ask this court to affirm the Court of Appeals decision. Thank you, Your Honors.
Thank you, counsel. Rebuttal.
The Seventh Circuit case, Reyes versus Dart, is important because it goes to the totality of the circumstance argument. The out-of-circuit cases that were cited, Reyes, Gardner, and Mulbaugh, all dealt with one specific instance, right? But when you look at the totality, such as in Badillo or Cheek, which are Rule 37 ones, or specifically Orlando residents, which is the case that I was trying to remember for Justice Earls' question earlier, that looks at the totality. In Orlando residents, they were looking at not just this litigation, but a history of litigation before the business court case, when there was a system of delay and use of litigation as delay. And based on that, the court found prejudice and that a failure to prosecute dismissal was appropriate of the cross claims. That is the totality of the circumstance argument married with the factors that should be used in this case. and has been used in Orlando, in the Don't Do It case, and also to some extent with Badillo and Sheik. Because with them, when they were looking at it, it was more than just, Smith v. Quinn was more than just one issue. Smith v. Quinn was filed on the eve of the statute of limitations, and the court made a point to say this was at the end of the statute of limitations period. You're at the end of the fairness period, and then you continue to delay. So Justice Dietz, I agree that it is not a heightened standard, but there is compounding, and there needs to be a consideration when you are filing at the end of the legalized time to file. It is potentially something and a factor that can be brought in addition to the factors in Wilder, because you are looking at the totality of the circumstances in the trial court. Bringing back to Justice Dietz, extrapolating to other rules of evidence, that's important. The abuse of discretion standard is there to defer to the trial court, who at times has to make hasty decisions at trial. And while they make those decisions, they are instructed that if they abuse their discretion or are not reasonable, they will be overturned. But that is an outer barrier, and it is fair, so that they can make the decisions and move forward with judicial economy. Chris v. Hill dealt with a situation where the Court of Appeals did not agree with how the trial court handled the situation of an attorney not appearing for trial, because there was not a phone call given to opposing counsel by the attorney or by the court. However, the court upheld the decision to dismiss the case because they are hindsight. If the court at the time felt that it was appropriate to do that dismissal, while not best practice, the abuse of discretion standard forbids overturning. And we ask you uphold it, Your Honor.
Thank you, counsel.
Thank you.
Mr. Clerk.